Alrighty, well, this is a whole nother class. Completely different. This is a very narrow area of the law. I say narrow. It cuts across several different aspects of law, really. Some aspects of tort law, contract law, corporation law, general business organization law. So it touches on several different subjects. And it's something that you're likely to encounter in your career, in the law practice, in the law business, because many law firms themselves are business organizations. They're out there trying to make money. And when I first started practicing law, virtually all law firms were partnerships. And so the goal of every young lawyer was to make partner in the firm. And some lawyers probably still talk about making partner, although very few law firms are still structured as general partnerships as they once were. There are more modern business forms that allow them to form as limited liability companies or professional corporations. Those were not options back in the day, and lawyers and accountants and doctors were not allowed to incorporate. It was against public policy because it would have resulted in limited personal liability for their professional malpractice. So the only options that were available to professionals were really to be in a solo practice by yourself, or if you wanted to practice with other in the same profession, you had to be a general partner in a general partnership or an employee of a general partnership. So there were a lot less alternatives available back then. Now, there's virtually no reason that any respectable law firm would be purely a general partnership. They might be a limited liability partnership, which is a relatively new creature in the law. And the focus of business organization law for the last several years has been towards greater and greater limited liability for owners. And this was to encourage people to go into business for themselves. So you see that over and over as we talk about business forms about limited liability. Well, you don't really have to have a business organization to do business, do you? You know, you can sell lemonade on the corner of the street, and it doesn't require a corporation, certainly, nor do you have to be any kind of formal business form. And there are many businesses. Some of you may have your own business. Let me just take a poll right quick before we get too far along here. Any of you own any corporations? Candace, was that a yes? Had one in the past? Yeah, okay. That'll qualify. Candace? What type of business was it?
Yes, I currently own a virtual assistant business that's an LLC, not a corporation, though.
Okay. LLC being a limited liability company. Is that a California LLC?
I'm sorry, it's in Washington.
Washington, okay, I forgot. Olga, you said you had one in the past. What type of business was that? Go ahead.
A few years ago, I owned something called OK Cosmetics. It was a small cosmetic business where I sold like cosmetic brushes and things like that. And then I was part owner of a Greek restaurant maybe 4 years ago. And then, let's see. Oh, that was it. The rest I just worked for.
How was the business organized for the restaurant?
Well, it was considered an LLC.
Okay.
But because it was me and my father, so I basically ran the entire business, and I was considered the vice president. And I reaped absolutely no benefits because it was my father. But I guess normally the person in my position would be, considered the manager. And he was more of a silent partner, and I was more, actually there all the time.
We'll talk about silent partners later on. I'm not ready to do that right now, but we will. Courtney, you say you're a sole proprietor, or were a sole proprietor? Go ahead. You had it on, and it was kind of faint.
This game again.
All right.
All right. Okay, can you hear me now?
Yeah. Yeah.
Okay. So they were sole proprietor except for one of the companies that I actually...
Turn your speakers down. You're getting feedback from your speakers. Plus, I was hearing myself. Go ahead. No, you can't hear me. That's why it's better to have a headset. Speakers are a problem. Anybody else had a business experience in the past?
Okay, now is it working?
All right. Well, Annette.
From, let's see, I guess 1994 to 2000, I was a licensed process server and a, not private, well, I guess you could say private. I own my own legal secretary business. What I would do was hire myself out. I lived in a small county, so I hired myself out to attorneys where if they had secretaries that were out on, say, maternity leave or family leave or for long periods of time, I would go in and I would fill in for, say, 2 months, 3 weeks, or if they were, if they had, for instance, one of the attorneys had a death penalty case that was taking up a large majority of his time along with other of his cases, but he didn't want to take away, he was a one-man shop, so he only had one legal secretary, but he still had his other clients. So I would go in and I would work solely on that case. So I did that for about 5 or 6 years, and that was my business.
What was the organization? What structure of the business?
So I had a business license with Solano County. I was the sole proprietor.
Okay.
I had a process server's license.
Okay, that's what I want to know. You were working as a sole proprietor, which is an informal business form. You don't have to create a sole proprietor. Sole proprietor is just a one owner of an unincorporated business. So that's a perfectly good way of doing business, but there are some downsides of that. There's some upsides of that as well, and we'll talk about all those things. So that's kind of what we'll be talking about. Each one of these business forms, how you create them, if they require creation, what their attributes are, what the upsides are, what the downsides are, and just kind of an overview, really, of business organizations and how they function. Business organizations are inanimate. They're considered, many of them are considered to be artificial persons in the eyes of the law, but of course they're not real persons. They're not humans like we are. So business organizations can only function through their agents. And so one of the first things that we got to get out of the way is sort of a primer in agency law. What is an agent? What's a principal? What's agency all about? What are the ramifications of agency? How do you create an agency? And so that's what we're going to talk about tonight. Chapter 1 and 2 deal with the principles of agency law. It's very theoretical. I got to warn you, there's a lot of theory, and this will be the theoretical part of the course. The first 2 weeks. Once you get the theory down, the theory pretty much stays the same, and is going to apply to each of the business organizations in a different way, slightly different way, but it'll be the same principles, the same agency principles. So it's good to have an understanding of them. Let's get the attendance out of the way, and then we'll go forward. Oh, I went one too far, didn't I? Okay, let's try it again. All right. Here we go. I forgot to do mine. We actually have more checks up than it noted, so that's all right. I know you're here. If I know you're here, that's all that counts, right? This is something I prepared some time ago on my own before I was using this book. So it's not out of the book. It's just my own thoughts on it. We're gonna look at one out of the book after this. But this is just kind of an overview, and actually in your book, you've got the same information in your book. Unfortunately, it's back in the back. It should be a preface to the book, but it's actually an appendix at the end. So take a look at that. It's basically the information we're going to talk about here. And so we're going to just identify the basic business forms that we'll be talking about, distinguish them somewhat, highlight some of the advantages and disadvantages that would be considered in choosing one form over another. And that's really the legal task that a client would come to an attorney law firm for. I'm going into business, or I'm in business. What sort of form do I need? And they may come thinking they need a corporation, or they need a limited liability company or a partnership. They may have something in mind, but different business forms are suited better for different types of businesses and have different advantages and disadvantages that the client needs to consider. So a lawyer would be able to advise them as to what would be best, but ultimately it's up to the client as to what they want. So first of all, we're just going to talk about types of business organizations. For many years, there were only 3 types, and that was the first 3 years: sole proprietorships, partnerships, and corporations. Those are still around, all of them, but we also have limited liability companies now, and limited liability companies bridge. It's a hybrid business form that tries to take best features of partnerships and best features of corporations and put them together in a single business form. And LLCs, or limited liability companies, are being used an awful lot for startup companies now. Sole proprietorships, unincorporated business conducted by one person. You don't have to create anything to be a sole proprietor. You just start doing business, and If you're the sole owner of the business, you are a sole proprietor, meaning you're the sole proprietor of a sole proprietorship. Sole proprietorship is a sole proprietor. There's really no difference between the proprietorship and the proprietor. It's all one thing. And the owner has responsibility for everything, which is both great and awesome. They have complete control over the business. They don't have to check with anybody as to what to do or how to do it. And they can change, very flexible. They can change their management strategy several times in the same day if they need to. So it's very adaptable to fit the situation. But the downside of a sole proprietorship is the liability. Because the owner is the only one there, they're personally liable for all the debts and obligations that business might generate. Personal liability simply means that the individual's personal assets are at risk for the business obligations, business debts, the torts that might be committed by that sole proprietor. There's no protection between the owner of the business and the business responsibilities, business debts, business liabilities. So it's the owner's personal responsibility. Partnerships are associations of two or more persons or entities. Can be an entity, can be a partner in a partnership, or it can be a human being, an individual. And they're in business together on an ongoing basis for profit. There's no non-profit partnerships. They're all out trying to make money. They don't all make money, but they're all trying to make money. So that's a big part of the definition. The two basic types of partnerships are general partnerships and limited partnerships. And we'll talk about the differences between those. The LLP and the triple LP partnership forms are just extensions of both general partnerships and limited partnerships. A general partnership can become an LLP, and a limited partnership can become a triple LP. And it has certain advantages that protects the general partners, basically, in both of those organizations. There are two types of partners, general partners and limited partners. The general partners are the persons who are both owners of the business and managers of the business. They run the show, whether it's a general partnership or a limited partnership. General partners run the show. Limited partners you only have in limited partnerships. You do not have limited partners in general partnerships. And a limited partner in a limited partnership is an owner, but they're basically a passive investor in that business. They're not a manager. They don't participate in management, and their trade-off is because they don't participate in management, they don't have any liability. They're liable for their capital, whatever they agree that they're going to put in as their capital investment, but that's it. And once that capital is fully invested, they have no more liability whatsoever for the operations of the limited partnership. General partners who run the limited partnership are the ones who have the risk. So in a general partnership, all the partners are general partners, meaning they're all owners, they're all managers, and all for one for all kind of thing in a general partnership. In a limited partnership, you have two kinds of partners. General partners, who are the managers, they run things, and the limited partners, who are passive investors. Both of them put their capital in, and their capital is at risk for both of them. But the general partners have more at risk than the limited partners because they have personal liability for the debts and obligations of the general partnership. Somebody sues the limited partnership or the general partnership, and it's the general partners who are responsible for that lawsuit. They could be their personal assets are at risk for that litigation or the debts of the partnerships, be they general or limited. The general partners are the responsible parties. The limited partners are not. Now, LLP, a limited liability partnership, is nothing more than a general partnership in which the general partners have obtained a form of limited liability. They're still general partners. They still run the thing. They're still the managers, but they've become more like limited partners. Now, the degree to which they become more like a limited partner varies from state to state. In some states, they have virtually the same position as a limited partner, except the only difference between them is that the general partners are still the managers, whereas the limited partners are not. The triple LP, that's just a limited partnership who has done the same thing basically, and it only affects the liability of the general partners. Limited partners already have limited liability, so they don't need any help. It's the general partners who are out there bearing all the risk in both the general partnerships and the limited partnerships. So the LLP form, or the triple LP form, it's really the same thing. It's just a different underlying organization that has attained this form of limited liability for the general partners. So the general partners have less risk when they have limited liability. And that's the whole idea. Excuse me. Now the third type, and I'm going through these hurriedly because we're going to come back and we're going to talk about all of these in wonderful detail. So there's no point in belaboring it now. I just want to give you an overview of where we're going. Corporation is an actual entity that's completely separate from its owners. In a partnership, partnerships are only made up of partners. And if you have no partners, there can be no partnership. And if you don't have two partners, there's no partnership. But a corporation, you can have only one owner. So that's different. And it's actually a separate legal entity that's completely separate from the owner, the shareholder, or shareholders, as the case may be. The shareholders elect a board of directors, and the board of directors has the overall policy decision-making for the corporation. They can delegate day-to-day management to officers, people with titles like president and vice president and so forth. And together, the board of directors and the officers constitute the management team of this organization we call a corporation. It's actually an artificial person created under the laws of a particular state. You can choose any one of the 50 states to create a corporation. And that corporation doesn't even have to do business in the state in which it's incorporated. So you can incorporate in Washington and do business in Pennsylvania or in Texas or Florida and not do any business in Washington. Or you could do the same thing anywhere. You could incorporate in Delaware and do business in California. The only requirement for incorporating basically is that you have an agent, a registered agent in that state, and they're there. Their sole purpose is to receive a lawsuit if anybody wants to file a lawsuit against a corporation. That's a pretty easy gig, you know. They don't do anything the rest of the time. They're just available with a registered office to receive the lawsuit, forward it to the home office. Really tough work. So it's good work if you can get it. There are professional organizations that offer to perform this service of being a registered agent. So there's some people ahead of you in terms of getting that money, but it's easy work. Corporations have a perpetual life. They live on and on and on. Until somebody kills them, basically, but they don't die when their owners die. Unlike a partnership, when a partner dies, partnership is dissolved. When a sole proprietor dies, the sole proprietorship is over. It dies. The business dies with the owner. Olga?
Question. When it comes to like one person in that state, let's say representing that corporation, can they represent multiple corporations at that particular address, or can they only represent that one particular corporation as per the laws, or does it vary by state?
No, they can represent as many different entities as they want.
Cool.
There's no restriction. Yeah, we'll talk about we're going to talk about agents tonight, and they are an agent. One of your first assignments is to change a registered agent, as an agent, they work for the corporation. But an agent can have multiple principals that they represent. Give you another example of that. An attorney at law is an agent who, and most attorneys have many clients. So that's perfectly all right. You can have a number of different clients. An agent can have a lot of different clients. The only restriction is that you've got to be careful that your principals don't have conflicts with each other. Because if they have conflicts with each other, that presents a conflict for the agent, the attorney, or the registered agent for the corporation. So they do have to, although a registered agent function is so limited that it's hard to see how any conflict could really be a problem for a registered agent. With an attorney, that's a different situation. An attorney can't be on both sides of the same lawsuit. You know, you can't represent one client on one side of the lawsuit and another client on the other side of the lawsuit. Represent the driver in an automobile collision and the driver of the other automobile on the other side of the lawsuit. That just would not fly. So when clients have conflicts with each other, the principals, that presents a conflict for the persons representing those principals in a more active way. All the registered agent does is just take the lawsuit and send it on. That's their sole responsibility. So very little that's going to create a conflict of interest for them. But it's different with a lawyer. Okay, corporations were the first entity that really offered investors protection from personal liability for the obligations of a corporation. The shareholders who own the corporation, their risk is limited to whatever they invest in that corporation, however much they spent to buy stock of that corporation. That's the measure of their risk. So they know exactly how much they're risking when they buy that stock. Corporations are more complex. They're formal organizations. They have what we refer to as double or dual taxation because corporations pay corporate taxes. So whatever earnings those corporations make, if they have earnings that are not needed for the business operations of the corporation, they can pass that on to the owners, the shareholders, in the form of dividends, and then they get taxed again in the hands of the shareholders. So the shareholder, in a sense, is paying taxes twice because the corporate entity is paying taxes, and then they're paying taxes again at the individual income tax rate on dividends. So the same earnings are taxed twice. That's the point. There are different types of corporations. Some terminology that you'll see later on in your book. I think I'm going to just kind of lightly go over that right now rather than get into it in any detail. But a public corporation is a corporation that basically what they do is furnish some governmental function, like the Federal Deposit Insurance Corporation. That's a public corporation. It serves a governmental purpose of insuring the deposits of banks. Private corporations are formed by private individuals for private business purposes. We're not going to talk about public corporations really at all. We're going to be talking about private corporations exclusively. And all corporations start out as private corporations that are business corporations. Those private corporations can be for profit or they can be non-profit. For-profit corporations are we also call general business corporations. They're there to make money and to make money for their owners. so that when they have profits, they can pass those profits on to their owners in the form of dividends. It's one way that a person can make money owning a corporation. You make money basically in two ways: with the appreciation of the value of your stock, or for the dividends that you receive from the corporation. Nonprofit corporations, it's not that they don't make profits, they do, but those profits are reused by the organization for their nonprofit purposes. Basically, nonprofits and tax exempts are almost the same thing. Not quite, because tax exempt status is determined by the IRS, whereas nonprofit status comes from the states. So you form a nonprofit corporation. The purpose of that nonprofit is to do something good, basically, to provide services for the poor, education, some educational institution, a library, Salvation Army, an organization that's out there to do good in the world. They make profits, but they reuse those profits for the benefit of the organization. They get criticized sometimes for their administrative expenses. They are entitled to have employees and pay their employees, and some of them pay their employees pretty darn well. So some of them are subject to a little criticism in that regard. A domestic, foreign, and alien is something you're going to hear over and over and over as it refers to business organizations. A domestic entity is an entity referring to that entity in the state in which it exists, where it's incorporated, where it's created. That would be that's the domicile state, whatever state that they're created in, and it's a domestic corporation in that state. Now, you don't have to do business in the domicile state. You can do business in other states. You have to seek permission to do so, and that permission is routinely granted. Again, you have to appoint an agent for service of process. It's kind of a ceremonial submission of the entity to the jurisdiction of the laws of that state, because they're now subject to suit in that state. So it's kind of like going and bowing down to the authorities in the state and saying, if you want me, I'm here. You can get me because my agent is here. And in order to do business in another state other than the state of domicile, you would apply to do business as a foreign corporation. So a foreign corporation is a corporation or a foreign entity, doesn't have to be a corporation, that's doing business in a state other than its state of origin, where it was created. An alien entity is an entity that's doing business in a jurisdiction, another country, basically. So like a company from the UK comes over here to the United States, it would be an alien corporation doing business in the United States. Whichever state it was in, it would be an alien. So it doesn't have anything to do with little green men or little things popping out of people's stomachs. It's just the fact that they're from another country. That's all it is. It's not an entity organized under the laws of the planetary system Xenon or anything like that. Okay. Publicly traded company. Publicly traded company is a company whose stock is available to the general investing public. You want to buy a company, buy stock in a company, you can buy it because it's registered on the stock exchange, like the New York Stock Exchange, American Stock Exchange, the NASDAQ. In the business pages, you'll see whole pages or columns of kind of letters and designations that are kind of alien looking, and numbers. Well, that's the trading value of their stock on the previous day. Does anybody read a newspaper anymore? We read the newspaper on the internet. But anyway, if you pick up the Wall Street Journal, you'll see all of these listings of publicly traded companies. And you can get current information about what the stock is trading for almost minute by minute. Sometimes the information is delayed by 15 or 20 minutes, but it's pretty close to the time when it's happening. Real-time information is available for a price. And so publicly traded, anybody can buy stock in that. Now, a closely held corporation, or a close corporation as they're sometimes called, closely held corporations owned by just a few shareholders, or maybe it's family owned. And a closely held organization will not, their stock will not be available, period. Because they have agreed that they will not sell their stock to anybody other than existing shareholders. So it's really closely held. And those shareholders may run the company directly. They may not even have a board of directors. But they have joined together in a shareholder agreement, a contract. And that contract's an enforceable contract. So if anybody violates the contract, they can be sued for any damages that result from them violating the contract. So everybody has to live with the contract. S corporation is a special type of corporation. It's a small corporation who has applied for subchapter S status with the IRS and received that designation from the IRS. The benefit of being a subchapter S corporation is that they do not pay corporate taxes, but rather the earnings are calculated for the corporation. They file an information return with the IRS, and they allocate those earnings and the deductions that they have to the individual shareholders that own that subchapter S corporation according to their ownership percentages. So each shareholder pays taxes for the S corporation at the individual income tax rate. Whatever bracket they're in is the rate at which they pay income taxes on subchapter S. So if you had a sole shareholder who owned a corporation, it would be most beneficial to own that as a subchapter S corporation so that they would not be paying double taxes. They would only file one tax return and would take care of it. Professional organizations or professional that allow professionals like lawyers and doctors and accountants to organize as a professional corporation or professional association. There are different types of professional organizations, even professional limited liability companies. And there's some unique features of professional organizations, but it's something that was not available back when I first started practicing law. So all those general partnerships, many of them are now professional organizations. Parent or subsidiary. Parent company is the owner company. Subsidiary is a company that's owned by another company. So that's some terminology you'll hear with corporations, and you'll hear some of that terminology with other entities as well, primarily the domestic, foreign, and alien. These are some corporation types. There are many corporation types. I don't want to spend a lot of time talking about this, but general business corporations is what we'll be talking about mostly. We'll cover closely held corporations, professional corporations, subchapter S, nonprofits. We will not be covering special purpose corporations like insurance companies or banks or utilities. These are organizations that are formed pursuant to specific statutes that regulate these entities and have special requirements that have to be met for those entities. So you're not going to learn everything there is to know about every type of business organization, but you're going to learn a lot about the ones that we talk about. Then the fourth one, limited liability companies. There are two basic types, owner-managed and manager-managed. They have their own terminology, and the owners are called members. So they're called member-managed LLCs, and they can elect a board of managers instead of to distinguish them from a corporation, which has a board of directors. And so in a manager-managed LLC, you've got a board of managers who's running the company. In a member-managed or owner-managed LLC, the owners are running the company directly. So if you stop and think about it, you've got two completely different ownership structures there. One very flat that looks a lot like a committee, somewhat like a partnership really, and another that looks has tiers of management, much like a corporation. So that's the general idea, that a limited liability company can be set up to mimic either a partnership or a corporation. Client choice, whichever way they want to go. Well, that's one of the really cool things about LLCs, the flexible management structure. So it is a hybrid business form, has some features of a corporation, some of a partnership, limited liability like a corporation, pass-through taxation like a Subchapter S corporation, and like a partnership, and a very flexible management structure. All states have LLCs, but the laws are different from state to state. You have more uniformity regarding corporations and partnerships because they've been around longer, and that's really the main reason that the laws are more uniform. Advantages and disadvantages, I'm going to leave you to the book, that appendix information in the back of the book. It goes through these various items and talks about them. We'll talk about each one of these factors when we talk about the different organizations. How easy is it to set them up? What's it cost? What's the management look like? What's the liability financial risk? Are they perpetual? Do they have a limited life? How easy are they to transfer? What about profits and losses? How do those get divided up? And I'll tell you what little I know about tax, which is not a lot, but I'll tell you what I know. I'm not a tax attorney by any means. So anyway, in summary, these are the major types of business organizations that we'll be talking about, and that's really all I wanted you to get out of this, just that there are a number of different types that we'll be talking about. Okay, as far as keys to success, I'll give you, this class is structured very much like the intro class. You'll have a chapter or two. Now, the thing that'll be different is that in a couple of weeks, we'll have 2 chapters instead of 1 chapter. But most weeks, we'll only have 1 chapter. So you'll need to read that chapter. It's good to read it before class if you can. If you can't, that's all right. It's more important to get your assignments and your tests and stuff done than it is to read the chapter that we're going to be talking about at the next class. But you do need to come to class because I'll be talking. I'll be talking a lot about Texas law because that's what I know. But we'll also be talking about general law, which is in the book, and so I'll be mainly pointing out differences where there's a wrinkle in Texas law that's different, because we've got a lot of Texas people in the class. I realize we've got people from a lot of different places in the class. So one of the cool things that you can do, all of the assignments are in terms of either Texas law or your local law, whatever that is. Now, in order to grade whatever you send me regarding your state, I've got to go find out something about the law in your state to evaluate that. So it's good for you, it's good for me to do some of that. And if you want to prepare your assignments exclusively under the laws of your state, that's fine. You're going to have to do the legwork to figure out what it is that you need to file, because I'm not going to be able to tell you. I'm not going to know. But I can find out whether what you've done is correct or not, and I'll be happy to do that. If you want to take the safe route and just do the Texas assignments, I do give you more information about, what form you use and so forth. You're perfectly welcome to do that too. So there's a little bit of risk in doing your own state but I can certainly understand why you would want to, and that's perfectly all right with me. I have no problem with that whatsoever. At any rate, you do need to take notes. There's some resources on Blackboard that will be useful to you. That's the question. Risk. Which way do you go? I don't know. You decide. You need to do homework. There are homework assignments. There are discussion questions for you to talk about, just like there were in the intro class. There will be self-tests to get familiar with the material that you're going to be tested on. And there's also quizzes at the end of each chapter that you need to take. Really, it's a weekly quiz. If we have 2 chapters in a week, then we'll have a quiz over both chapters at the end of the week. So study, do the self tests to study for the quizzes. It's not going to give you the right answers, so you still got to look up the right answers in the book and learn the right answers. So there's going to be a fair amount of memorization for you to do. But getting things in on time is the most important thing, because the school has a policy against receiving late work. Now, you know, if you're in the hospital and you're receiving, you're in intensive care, something like that, that's a different situation. But I do drop one assignment or quiz or discussion question from your grade. So if it's just one thing you miss, then as long as you don't miss anything else, it's not going to hurt your grade. Savannah?
Oh, dang it, I forgot what I was going to say.
All right, well, when you think about it, when you think of it, just ring in again. All right. So do the assignments, turn them in on time, study for the quizzes, do the quizzes, and make sure you do those on time. Do your best. That's all I ask. Do your best, and I'll do the rest. Any questions? Savannah.
I remembered. Is there a way that we can set Blackboard to where it'll remind us when our assignments are due for your time instead of where I'm at, like in Washington? Because it's only 5. It's 6 o'clock here. Almost 6 o'clock.
Yeah. Well, it'll need to be done on your time, right?
Yeah.
All it tells you is what time it's due here.
Yeah.
Right?
Yeah. Is there a way that we can change?
I don't know. I doubt it. I doubt it. Not that I know of. Unless you can, in the calendar, if you can change your location, it may be possible.
Okay, I'll try that.
I just don't know. I think that's where it would be. Olga?
I just wanted to know, so none of the classes that we take with this school have final exams, or you're not sure, or are there any?
Some will.
Yeah? Some
will have a final exam.
Okay. Thank you. Does this one?
and I have a final in one of my classes.
Okay. Cool.
So,
does this class have one or no?
No, we just have weekly quizzes, and that's it.
Okay, cool. Thank you.
So you only have to remember things for a week.
That's good, right?
It'll be challenging enough just remembering it for a week. So, Virginia?
Yeah, I have 2 questions. The first one is, how is the grade done? And the second, is there classes on Wednesday before Thanksgiving?
Okay, good. I'm glad you brought up Thanksgiving, because I forgot that next week is Thanksgiving. Next week, as a matter of fact, I'm going to be gone, so there will be no class as such next Wednesday night. But there will be we will post a recording of a previous class that you can watch. It will be just lecturing on the subject that we're supposed to cover next week. And you don't have to do that on Wednesday. You can do it the day after Thanksgiving or the day before our next class. You can do it whenever is convenient to you. But there will be assignments due next Wednesday at 6 o'clock. Okay, so that should not interfere with your travel plans, whatever they are. If you get your work done earlier, then you're perfectly free to do whatever it is that you need to do for Thanksgiving, and just watch that video. It'll be posted. I don't think it's been posted yet, but it will be by next week, and then you'll have the same stuff to do for that second week with discussion questions and assignments and so forth, quizzes. Glad you brought that up. What was your first question? The grading. The grading.
How's the grading?
It's exactly the same as the intro class. 30% with the quizzes, 30% with the discussion questions, and 30% with the assignments, and then 10% for participation.
Okay. Okay, thank you.
You bet. Anybody else? Hours in attendance will be exactly like we did in an intro. There's 6 hours each week for 8 weeks. That's 48 hours. 2 hours of the 6 hours each week is class attendance. If you're here for 1 hour, you get 1 hour credit. If you're here for both hours, you get 2 hours credit. And then the other 4 hours is based on just participation, the things that we see that you do. The discussion questions, there are 2 of those, so we count 2 hours for that. It may not take you 2 hours to do it, but you get 2 hours participation credit for doing both discussion questions. There's 1 hour for the weekly quiz and 1 hour for assignments. So that way, if you do all those things, then you get all 6 hours each week. That's the way it works. For Thanksgiving, probably everybody will get 2 hours for that. I mean, there's no way that I've been able to figure out to look through this camera to see whether you're reviewing the video or not. Some teachers will tell you different, but I don't know of a way to do that. Pop quiz. No, I don't do pop quizzes. It takes time. The standard, and this is a school standard, is not mine, on the discussion questions is to do at least 2 responses. I mean, in order to be a discussion, it's supposed to be a written discussion. Well, if all you do is post and you don't read anybody's or respond to anybody's, it's not really a discussion, is it? And I'm pretty liberal, I mean, as long as you're responding, it doesn't have to be a long, drawn-out thing. What ideally, it would be something that would be of interest, that you would actually be getting something out of the conversation. And I've found myself in participating in classes as a student that I learned a lot in the discussions when we talked about we took some classes in Blackboard of how to do things, and I was really surprised that I learned as much from the discussions as I did, because we had teachers who were all trying to figure this thing out, and others were very helpful. So it may depend on the subject, what you're talking about and how easy it is to do that. Some of them will seem like just a legal assignment, and you might forget to do a response. Well, you're going to get dinged for no responses. But don't let that happen. Just make it automatic to do that, and then you don't get dinged, and we're all a lot happier. I want you to make good grades, and you want to make good grades, so just do the responses. If I gave everybody credit without the responses, then we wouldn't have a response rule, would we? So that's the name of that tune. Essays, no. On the in intro, in some of the questions, some of the quizzes had essay type questions. I don't believe we've got any essay type questions in this class on the quizzes. It's the writing assignments are as close to that as you're going to get, where you're responding to a fact situation and applying information that you've gotten out of class, and you're applying it to that fact situation. All right, well, why don't we take a break, and we'll come back and we'll talk about agency law, because we need to. Okay? Still got a few that are not back. All right, you're supposed to be back by now. Okay. Laura. Savannah. Olga. Derek. There's Laura. Okay, here we go. That's pretty good. I think that's better than we did first hour. That's pretty good. I'll take it.
Hey, Doc.
Where were you?
I can't see my screen
okay.
where you.
Okay, that's fine. It's cool.
I'm gonna have to go out and come back in because all I can see right now is the comments.
Okay. That's fine. Go ahead. All right. Well, we're working up to the actual official PowerPoint of the evening. I like mine better. And so this is done not to confuse you, but to try to simplify agency. Agency is a relationship. It's a relationship. It's a legal relationship created when one person, an agent, acts on behalf of another person, the principal. The agent represents the principal. So this relationship gets created by mutual agreement. It's what binds the principal to the agent is their agreement or contract. May be a formal contract, may just be handshake. But a principal is someone who's represented by an agent. An agent is someone who represents a principal. They're each defined in relation to the other, which just reemphasizes the fact that it is a relationship. You can't have an agent without a principal, although you can have a principal without an agent. Principal is the boss, the relationship. They're in charge of the relationship, and the agent is an agent in the representative capacity. They represent the principal or the boss in whatever endeavor it is. The agent for service of process, their sole representation is to receive notice of a lawsuit and forward that to the principal. That's it. That's all they do. They don't negotiate contracts. They don't sign things. They have no authority beyond what I just told you. They receive a lawsuit, they forward it. That's their sole responsibility. Other agents have more responsibility. This agreement can be a formal service contract, could be like an employment contract. A power of attorney is a legal document to create an agency relationship. In a power of attorney, the agent may be called an agent, or they may be called an attorney in fact. An attorney in fact has nothing to do with an attorney at law. It just simply means that they're an attorney in the same way that an attorney at law represents a client. An attorney in fact is someone who represents someone as an agent. So power of attorney is a formal legal document to create an agent. One of your assignments is to create a power of attorney. And I say create, and I mean create. You're not going to find a form that's perfect, I don't think, for your purposes. It's a specific fact situation, and so you're going to have to do a little creative drafting. Don't be afraid of it. Just put it out there. You can copy the information right out of the assignment, slap it into a power of attorney, and it's amazing. It will work pretty well. But you may have to take some things out of the power of attorney form that you find. So you might have to read it to determine whether it makes sense or not. Okay. Other ways of creating an agency could be just a business relationship, like employer-employee is a type of agency agreement. There we go. There's one. Can you think of other types of agencies, agents that you've heard about out there? The principal delegates authority to the agent, comes from the principal down to the agent. So what other kinds of agents are you familiar with? Anybody ever heard of an agent? Who has agents? I'll have my people get hold of your people. Insurance. Okay, insurance agent. Insurance agents, do they represent the buyer of insurance, or do they represent the seller of insurance for the most part? Farida, you mentioned it. Who do they represent?
Can you repeat the question, please?
Who does an insurance agent represent? Do they represent the insurance company, or do they represent the person that's buying the insurance?
Insurance company, right?
Yeah.
Yeah.
That's right. They represent the insurance company. Virginia?
You meaning like realtors? Realtors are considered agents, right?
A real estate agent, absolutely. That is an agent. And they can represent either the buyer or the seller in the transaction. There is a customary way that they usually do it, because the commissions only get split on one side of the transaction, so they usually represent that side of the transaction where there's a commission. But they can represent either the buyer or the seller. And then you've got a tax preparer, who's an agent, who prepares taxes for people. Politicians. No, that's a little murky. To see how that. I mean, they represent us. Yes, they do. But there's less of a direct. We don't really control what they do individually anyway. We do collectively. So collectively they are our agents. Yeah, so there's some parallel. What do you mean by the company? As a couple of you say the company. The company is an agent? Oh, you were talking about responding to my question about who does the insurance agent represent. Okay, I got you. President is an agent of the United States. Yeah. There's some aspects of agency there. I don't know that there's no contractual arrangement. Financial agent, yeah, okay. Celebs, I see up there. Celebrities have agents. Sports actors, sports players. Those are good ones. They do have agents, and they're different kinds of agents. Some agents are negotiating agents. They negotiate a deal, but who signs the deal? The actual principal usually signs the deal, not the agent. So they negotiate a contract, but it's up to the principal to decide whether that's an acceptable contract or whether they're going to sign it or not. There are other kind of agents, like a booking agent for a band, let's say, who will actually sign up the gig. They will enter into a contract on behalf of the band. And many agents have contracting or contractual authority for the principal. That's one of the main reasons that principals have agents to represent them in contracts, in contractual matters. So that's one of the things that we'll talk about. The authority flows downhill. However it gets communicated from the principal to the agent, whatever is communicated is their actual authority. That's how much authority the principal has actually given to them expressly. And so that authority can be very narrow, like sometimes when parents are going out of town and they're not taking the children on vacation, they'll have somebody to stay with the children and authorize somebody to obtain medical care for the children if needed. So they would sign a power of attorney, appointing an agent whose sole responsibility would be to authorize medical care if needed for the children. So that would be a very narrow authority granted. The authority can also be very broad. You could have a general agent or a universal agent, someone who is empowered to do anything and everything that you could do if you were physically present. In other words, you can appoint an agent, and by appointing that agent and giving them very broad authority, you can legally clone yourself so that there could be another mini-me walking around out there with full authority to represent you in any transaction that they might run across. So they could write checks on your bank account, they could withdraw money from your bank account, they could clean out your bank account, they could sell your car, they could sell your house, they could sell everything that you own. That's broad authority. And you would think long and hard before you would give someone that kind of authority. It would have to be someone that you trusted basically with your life, because that's essentially what you would be giving it. Candace?
Yes, are you going to speak about the difference between general versus durable power of attorney?
I hadn't planned on it, but I can. A durable, one thing about a power of attorney, when you create a power of attorney and appoint an agent, it can terminate on a specific date if you want it to. It can terminate on any specific event if you want it to by agreement. Whether you specify how it would terminate or not, a ordinary power of attorney will terminate upon the death or the disability of the principal. So the idea here is that the principal is, since the principal is providing authority, the principal is also providing instructions and direction of the agent. They're controlling the agent. So the agent is reporting back to the principal what it's doing and what information it has available. And the principal is instructing the agent as to what to do next. That can be done orally or can be done in writing in the power of attorney itself. But when the principal dies, it's no longer capable of providing instruction. And if the principal were to become disabled to the point that it could not communicate with the agent, could not provide instructions, and so the law has been that with an ordinary power of attorney, not a durable power of attorney, but an ordinary power of attorney, when a principal becomes disabled, that the agency will terminate. A durable power of attorney, on the other hand, once created, will specify that this power of attorney will not terminate upon the disability of the principal. So that if the principal became disabled in a fugue state or unconscious and was unable to communicate, the agent could continue to function as their agent even though the principal would be unable to provide direction. Now, once you've appointed an agent pursuant to a durable power of attorney and you become disabled, unable to provide instruction, it is then impossible for the principal to terminate that agency relationship. And the only way that it can be terminated is by the appointment of a guardian, which is another legally appointed agent. A guardian is an agent appointed by a judge to represent a principal who is disabled. And once a guardian is appointed, all powers of attorney are terminated as a matter of law. Even if one has a durable power of attorney, when the principal dies, it still terminates. Did I answer your question?
I used to be a director
Candace?
Well, yes. Yeah, it did. But then I'm curious to know, can you hear me? Oops.
Yes.
Are you able to hear me?
Yes. Yes.
Okay. I think I think the audio is a bit delayed. Okay. So I used to be a director in a assisted living, and we used to have, deal with powers of attorney all the time for our residents. And some would be, they'd have a son or daughter that would be the medical power of attorney, and then somebody who would be the financial power of attorney. So you set up these separate powers of attorney. How exactly does that work? Is that just something you set up separate ones and designate that within the language of the document?
Well, you would have separate documents. They don't have to be separate agents. Could be the same agent. The same individual could handle both the financial and the health, but they're two different
unless
forms.
You had. Yeah, I think we used to have an issue with some of them where, like, you'd have a son who maybe they didn't want them handling the money, but maybe had them handling, some other part of the of the thing, and then somebody who had to handle all the medical. So yeah.
Right. They can be different agents, or they can be the same agent, but it would be two different forms. Courtney?
Try this again. Can you hear me?
Yes.
Or are you still getting feedback?
No, go ahead.
Okay. In California, at least, we have a living trust for this situation that I'm in now, and I am the trustee as well as the beneficiary, and I am also in charge of her medical directive. That is what they're calling it now, is a medical directive. But there is a binder we have that has different sections for each one of these, the power of attorney, the medical directive, the trustee, et cetera, et cetera. And that's how we set ours up anyways. The previous trust that we had with another grandmother was a little bit different, but not really all that much. It was just a matter of wording or just the way that it was laid out in the binder. It was actually, by all intents and purposes, I think it was exactly the same in the end result. But that's all I got for you.
Okay. Well, there's lots of different ways of having an agency relationship. One of the main things that we're going to be talking about next week is the agent's authority to represent the principal in signing contracts with third parties. And so you've really got two different contractual arrangements that you're concerned with. Whatever the contractual arrangement, if any, between the principal and the agent, and also the contractual arrangement that's going to be entered into with the third party. Who is that really with? Is that with the agent or with the principal? And it depends. The desired effect is that it's going to be the principal who is the responsible party on that, but there's several different contingencies that can affect that. So I'm not going to get into that now any more than we need to talk a little bit more about how you create an agency. So let me move from this to the official PowerPoint and the points that it wants to do. It's going to define agency for you as well, and identify, define, and distinguish between employer, employee, principal agent, and principal independent contractor relationships. These are really three distinct relationships, and we'll talk about each one of them and describe the different types of authority an agent can have. We've already talked about actual authority, but there are other kinds of authority. Describe the duties that principal agents have to one another, and describe how agencies are created and terminated. So we've already talked about a little bit about all of this, but we're going to come in with a little more detail now. First of all, you have a principal and agent. An agency is a fiduciary relationship. I think we introduced fiduciary relationships in intro, did we not? That it's a relationship of trust and confidence, and out of that relationship of trust and confidence come duties, which are called fiduciary duties. Things like a duty of loyalty, a duty of obedience, a duty of due care. There's several of these fiduciary duties that arise out of fiduciary relationships. So the agent has fiduciary duties to the principal, and the principal has some fiduciary duties to the agent because of this relationship. So what is the nature of agency? Well, agency law, it's a large body of common law, meaning basically it's going to be cases, not written down in statutes, but it's common law. What's come to us from cases, decisions. It's a mixture of contract law and tort law. The principal is the party who employs another person to act on his or her behalf, and the agent's the party who agrees to act on behalf of another. That's repetitive. It's just reiterating what we've already said. There's some sort of contractual arrangement or agreement between the principal and the agent. That's the most basic relationship, and then that agent can contract with third parties. When they do so in a representative capacity, representing the principal. So the real contract will usually be that the principal has an obligation to perform the contract with the third party. The agent may sign it, but when they sign that contract, they sign, it's as if they're signing with the principal's hand. And the principal is the one who typically is bound to that contract, so long as the third party knows who the principal is and knows that the agent is representing that principal. That's a big condition there. Obviously, if they don't know who they're dealing with, then they only have a contract with who they know they have a contract with. Okay. Now, persons who can initiate an agency relationship. Anybody who has the capacity to contract can appoint an agent to act on his or her behalf. So what does that mean? You have to have contractual capacity. You can't be of unsound mind. You can't be insane. You can't be a minor. So if you have contractual capacity, you can appoint an agent. Basically, you have to be an adult and you have to be of sound mind. Well, you know, I guess I can appoint an agent. It's debatable. Persons who can initiate still. An agency can be created only to accomplish a lawful purpose. So, for instance, you could not hire a hitman to be your agent. Would not be an agent in law because that would be for an unlawful purpose. Agency contracts that are created for illegal purposes, any contract that's created for illegal purposes is void and unenforceable. It's totally against public policy. So, you know, if you get if your drug connection screws you out of a bunch of money and doesn't come through with the drugs, sorry, there's no contractual relationship there that you can go to court and sue on. So self-help is your only recourse. There's no recourse to the courts for illegal contracts. Kinds of employment relationships. Okay, here we go. And we call all of these employment relationships, they're not really employment relationships. And well, I'll clarify that. Employer-employee clearly is an employment relationship. We call a principal and an independent contractor relationship an employment relationship because a principal is hiring an independent contractor to do something, to do a task, to do a job. But the difference between an employer-employee and a principal independent contractor is that the independent contractor may have their own business They're separate business. They don't work for the principal all the time. They're working for the principal on a contract basis, a temporary working relationship. They may have a number of principals that they contract out with. There's some paralegals that work like this as an independent contractor, hiring themselves out to different attorneys on a task-based basis to accomplish a particular set of tasks that need to be done, and they may be working for several different attorneys at the same time, doing similar kinds of things. That would be an independent contractor relationship. They're not an employee. An employee is someone who works for somebody more or less all the time. Now, they're part-time employees, which is a little bit different, but they're still working at the employer's place of business, doing the employer's in control. They're usually closely supervised by the employer. Independent contractors loosely supervised. It may not be supervised at all by the principal. And you hire a plumber to come into your house and fix your plumbing. Well, they don't want you looking over their shoulder anyway. They know how to do what they're going to do. They have their own tools. They don't use your tools. They bring their own tools. They have their own office, their own source of transportation. You don't supply anything other than the place for them to come and work in your house. So that's what an independent contractor is. So there's some other distinctions, like an employer-employee, you have to do tax withholding for employees. Independent contractors, you don't. The independent contractor is responsible for the payment of their own taxes, so they pay independent contractor taxes or self-employed taxes. Whereas an employee, the employer pays those taxes for the employee. Now, what's a principal-agent relationship that's, employer-employee can involve principal-agent, independent contractor relationship can involve principal-agent, but a principal-agent relationship can also be neither employer-employee or principal-independent contractor. What would that be? Can anybody think of a principal-agent relationship that's neither employer-employee nor principal-independent contractor? What's unique about both those relationships that might not exist in a pure principal-agent relationship? Farida, do you want to take a whack at it?
Yeah, what about the health aide being responsible for the elderly?
Okay. Yeah, if you someone who is appointed an agent, a healthcare agent, is there any compensation involved there?
Of course. Yes.
Well, not necessarily. I mean, you could appoint your daughter as your agent.
Yes.
To care for you, take care of your health if you're unable to communicate with your doctors, and there would be no compensation whatsoever involved. But you're still appointed an agent. What's unique about employer, employee, and principal independent contractor? There's remuneration. There's money changing hands here, and money does not always change hands in a principal-agent relationship. It can certainly be an employer-employee relationship or a principal-independent contractor relationship, and also a principal-agent relationship. But a principal-agent relationship can exist outside of either employer-employee or principal-independent contractor. Does everybody understand what I'm saying? That if you have a family member who is appointed as your agent to do something, to handle your finances or to handle your health decisions if you're unable to communicate with your doctors. Yeah, that's a principal-agent relationship. It is. And there are fiduciary duties that arise out of that relationship. And yet, it's not an employer-employee relationship, and it's not a principal-independent contractor relationship either. It's neither. So these are three distinct kinds of relationships. And principal-agent relationship can be independent of either, or it can overlap employer-employee and principal-independent contractor. There are principal-independent contractor relationships that probably don't rise to the level of principal-agent in the same way. It still is a principal-agent, but it's handled in a completely different way. They may have no contracting authority whatsoever, to sign contracts on behalf of the principal. The plumber can't sign a contract for the homeowner. That's not what they're hiring the plumber for. They're hiring the plumber to fix the plumbing. What about torts that the plumber might commit? Are they responsible for the torts of that independent contractor? Probably not. Probably not. Now, if it's an employer-employee relationship, anybody remember what the rule is there for tort liability? We're going to talk about this next week. I know we talked about it in intro. It has there you go, Laura, you get the gold star. Respondeat superior. That's the rule in tort, that the employer is responsible for the torts of an employee that are committed in the course and scope of their employment. So in a principal-agent relationship, it's also an employer-employee relationship. The employer would be liable for the torts of the employee. If it's an independent contractor, respondeat superior doesn't apply. And so there's an exception that everybody's liable for their own torts. That's not the that's a general rule. Everybody's liable for their own torts, but it's an exception to the respondeat superior because there is no respondeat superior relationship when it's an independent contractor. Now you will see and hear in this chapter that in a principal agent, well, we'll get to that next week. I don't want to get into that right now. Anyway, employer-employee. So relationship results when an employer hires an employee. There you go. There's money changing hands to perform some form of physical service. Employee is not an agent unless he or she is specifically empowered to enter into contracts on the principal employer's behalf. Not an agent for purposes of signing contracts. Is an agent for purposes of committing torts. And that's a critical distinction. So the book doesn't consider them to be it's a principal-agent relationship unless they have contractual authority. They may be right about that. Principal-agent relationship, an employer hires an employee, gives an employee authority to act and enter into contracts on his or her behalf. Okay. That would be both an employer-employee relationship and a principal and agent relationship. Or a husband appoints his wife as his agent to handle financial affairs or to buy or sell a house, and nobody hired anybody, but it's still a principal-agent relationship. So there, you can have both an overlap of employer-employee principal-agent, or you can have principal-agent standing alone. The extent of the authority, Laura, I'm getting feedback from your mic, I think. There, thanks. The extent of the authority that the principal has given to the agent is going to be governed by the agreement between the principal and the agent, and whatever is implied from the circumstances. That's implied authority. There's a preview of different types of authority there. Laura?
Hi, sorry about that. I just had a question about the difference between a paralegal who is on a temporary contract basis and who has not been employed by the attorney yet. Is it still respondeat superior until they're hired? I mean, if it's just contract employment, how does that work exactly? Because I'm kind of on that right now with the attorney I'm working for.
Okay. Is your deal directly with the attorney, or are you going through another agency?
It's through CALS, but it's directly through the attorney, I believe. Okay. I mean, he's the one that contacted me.
All right. Well, you could be either. You could be an employee, or you could be an independent contractor. They're probably going to treat you as an independent contractor, would be my guess. If you're there temporarily, or is this a permanent?
I think it's just on the basis to see how I'll do in the next 3 months, and if he wants to hire me full time.
Okay. Well, until you're hired full time, I think you're probably an independent contractor. I doubt that they're going to treat you as an employee in the period of time. They're probably just treating you as an independent contractor. Temporary employees quite frequently are called contract employees, which is almost an independent contractor. A lot of times they are independent contractors. You know, it gets kind of murky when you've got an agency who has an agreement. An independent contractor agency has an arrangement with an employer, and pursuant to that arrangement, they're sending out temporary contract employees. So the temporary contract employees are employees of the agency, but they're considered independent contractors to the party that they're working for, ultimately. If that makes any sense. I don't know. That just kind of complicates our discussion here, so everybody ignore that. Principal independent contractor, let's focus on that. It's where a principal employs a person or a business who are not employees. That's the upshot of it. They're not employees to perform certain tasks. The main difference between an employee and an independent contractor is employee is there on an ongoing basis. They work at the employer's place of business, subject to the employer's rules, subject to the employer's supervision. They're paid on a regular, repetitive basis. They do the same tasks over and over and over on an ongoing basis. An indefinite or indeterminate duration, would be a hallmark of an employment relationship. It could end tomorrow, but it's indeterminate. It could go on for years as well. Whereas an independent contractor relationship is more task-based, that you're there for specific tasks. Could be a trial period, would be an independent contractor, I think, until you're actually hired full-time. That would be my guess. They're probably not withholding taxes. Now, if they're withholding taxes, federal taxes, then they're treating you as an employee for purposes of federal income tax, which is better for you if they do. Principal can authorize an independent contractor to enter into contracts. If they're just there to perform a service, obviously not. But if you, an agent for hire like an agent who represents celebrities and so forth, they're independent business people. They're not employees by and large. They're independent contractors. They represent many principals, and they're negotiators. They're there to represent the interests of the principal. And they are authorized in many cases to enter into contracts on behalf of the independent contractor. On behalf of the principal is what I meant to say. Even I get confused in this. Sorry. The crucial factor in determining whether a person's an employee or an independent contractor is the degree of control. You know, how much supervision is the independent contractor subject to? Not much, usually. If the principal is controlling everything that the independent contractor does, then they may not be an independent contractor. They may be an employee. So the greater the degree of control, the more likelihood that they're going to be treated as employer-employee relationship. So that's a facts and circumstances-based test. You know, you take each situation and you look at it and you say, how much control did person A have over person B? And the more control they have, the more like an employer-employee relationship than an independent contractor relationship. So, in summary, different kinds of employment relationships. In an employer-employee, the employer has the right to control the physical conduct of the employee. They know where they are. They're responsible for their behavior. Principal agent, the agent has the authority to act on behalf of the principal as authorized by the principal and implied from the agency relationship. An employee is often the agent of his employer. In another sense, an employee is always an agent of the employer, just for tort purposes, not contract purposes. Okay, principal independent contractor. The principal has no control over the details of the independent contractor's conduct. Virtually no control. They hire him out the work. You've heard of outsourcing. When somebody outsources a task, they're hiring an independent contractor to take over that task. They're not hiring employees to do that. That would be insourcing or handling it in-house. But outsourcing is all done through independent contractors. Independent contractor usually is not an agent of the principal. Usually not. They can be if they are an agent. If it's a principal-agent relationship, then the principal may be responsible for the actions of the independent contractor. Because the law says, and I use the law loosely, because it's not written down in the statute anywhere, but the restatement of agency, which is the authority of agency law, says that principals are responsible for the actions of agents while the agent is acting within the scope of the principal's authority. So if an independent contractor is an agent, then that would prevail. That methodology. We'll get into all that next week. All right, formation. There's express agency, which is the actual communication between the principal and the agent. There's implied agency, which arises out of the circumstances of the agency relationship. And then there's apparent agency, which is what it looks like from the standpoint of third parties. And then you have agency by ratification, which there is no agency, but an agency is actually created after the fact, after something has been done that was not expressly authorized, did not come within implied or apparent authority, and the principal chooses to accept the thing that was done. So the acceptance of an otherwise voidable act is ratification. So they can create an agency by ratifying after the fact what's been done. Expressed agency is the agency that occurs when a principal and agent expressly agree to enter into an agency agreement with each other. So they sign a contract, exclusive agency contract, a power of attorney, whatever the nature of it, whatever they've expressly agreed to is their express agency and their express authority. Express agency contracts can be either oral or written, unless the statute of frauds stipulates that they must be written. Statute of frauds, in case you don't remember, I know we touched upon it. Statute of frauds is any statute that requires certain contracts to be in writing. So specifically, contracts that convey an interest in real estate is one of those things that needs to be in writing. There are others. Implied agency, Derek?
Yeah. How can a person who's working for the state of Texas prove agency? Because the state of Texas is a dead corporation. So how is agency proven in that manner?
That's an interesting question, and I'm not sure that I know the answer to it, other than you would have to find something either in the statutes, the authorizing statutes for an actual agency of government, or in the regulations of that authority that gives the agency of government authority to delegate to someone else, to an individual agent. And so it's probably buried in the regs somewhere. But it could also be in the authorizing statutes. And then how that authority gets communicated within the agency, that's probably a matter of a regulation within the agency.
Now, the other thing, too, is government is supposed to be established by the people. And I'm assuming that we are the people. I'm not sure. So, isn't that a principal-agent relationship there?
Well, you know, the more I think about it, the more I think not. Because it's not a one-to-one kind of a deal. You know, a congressman or a senator or a governor, let's say, they have thousands and thousands of people that they represent, millions in some cases. And, you know, to say that they're an agent of every one of those people, it would be impossible. It would be impossible to serve directly the interests of every one of those people because they have conflicting interests. You know, it just agency law breaks down when you try to apply it to government. I think government is a special situation that we have representative government, true, but I don't think it's a true agency relationship. One-to-one.
Right, well then that's what I'm saying. Then it's not really by consent of the government then. If we can't call them to task or pull them on the carpet about something that we don't agree about, then it's not. That's not really.
You can pull them on the carpet, but they don't have to do what you say. They represent you, but they don't have to do what you say. That's representative government. That's not agency law. It's just something. Okay. It's just something completely different. All right. So I'm sorry we got into government. That's never really come up before. Husband and wife usually comes up as an agency relationship, and I don't like that one either because
same thing.
It's the same kind of you know, who's on top, who's the principal and who's the agent. And do you always have to do what your spouse says? Well, if you're the husband, yes, you always have to do what the spouse says. If you're the wife, then the answer is no. Okay. I think we've got that clear, right, ladies? Okay. There are more of them than there are of us, Derek, and so have to tread gently. Implied agency. This is the agency that occurs between a principal and agent. It's not expressly stated by the principal to the agent, but it's agency authority that's implied from the conduct of the parties. For example, if a employee has authority to open and close a store, then well, let me go another way. Let's take a corporation. Corporation has a corporate treasurer, and the treasurer's responsibilities are set out usually in the bylaws of the corporation. So they're to handle bank accounts and financial matters for the company. That's their general authority. Well, the express authority may be general in nature like that. So that means they have authority to negotiate with the bank the rates for which they will allow the corporation to have a corporate account. They will be able to set up corporate accounts for their corporation with the bank because that authority is implied from their very office, from the position that they hold. So that's what implied authority is. It's authority that flows from express authority that is actually needed to perform the express authority that one has been expressly given. So you have whatever additional authority is implied from that relationship. Incidental authority is another type of implied authority to act. But it's facts and circumstances based. It arises out of whatever the express authority is. Now, apparent authority, and I wish they'd used authority instead of agency. It's more descriptive of what we're talking about. Apparent authority of the agent arises when a principal has created the appearance of an agency that in actuality does not exist. If you had a department store manager that printed up little signs for all of the clerks in the department store that says manager, because the clientele would feel better about being handled by a manager than a clerk, then the store has created the appearance of that clerk having manager authority. You follow me? So apparent authority stems from the principal. Yes, it's something that the principal did to create the appearance from the standpoint of the third party dealing with the agent, that the agent has more authority than they actually do. Well, the thing of it is, if they appear to have that authority, then they probably do have that authority. And the principal is stopped or prevented from denying the agency relationship. And it's the principal's actions really that create this appearance of apparent authority or apparent agency. So it's not real, but the third party doesn't know that, so they get the benefit of the appearance. That's the gist of it. Agency by ratification occurs when an agent really acts beyond their authority. Either they misrepresented themselves or they just are acting in a way clearly beyond their express authority, and they know it, but they do it anyway. And if the principal is really not bound by that. by the way. If there's no authority for the agent's action, then the agent's out there on their own. They have not bound the principal if they're misrepresenting their authority or they're exceeding their authority. But the principal can always back up the agent and say, well, okay, you acted out of school here. You shouldn't have done what you did, but actually it's a good thing, and so I'm going to accept this deal and create, after the fact, the agent's authority. So they're bound, the principal binds themselves voluntarily to an act that they otherwise could disavow and say that was unauthorized, I'm not responsible for that. But if once they ratify it, then they are responsible for it. Okay, summary, formation of agency relationships. You can do it expressly. It's authority that's expressly given to the agent by the principal. That's what we initially talked about, the authority that flows downhill from the principal to the agent. They enter into a contract. The principal and the third party are bound to that contract. The agent's authorized to enter into it, so they represent the principal when they sign the contract, and the principal and the third party really are bound to the contract. Implied authority comes from the conduct of the party's custom, usage of trade, or act incidental to carrying out the agent's duties. It's necessary for the agent to perform their express duties. Principal and third party bound to the contract, either with express or implied authority. Apparent authority, same thing. Principal and the third party are bound to the contract. Even though this was an authority that was misleading in a way, the principal is not going to be able to deny it. Having created this misappearance, they're not going to be able to deny that the agent was not authorized or claim that the agent was not authorized. They're going to have to stick with the agent because they've created the appearance of the agent having more authority than they actually have. By ratification, where the agents acted outside of their authority, the principal and the third party are not bound to the contract unless the principal ratifies the contract. Okay, the latter part of this has to do, and I'm out of time, but the latter part of this has to do with the duties that agents and principals owe to each other. I think you can get that out of the book. We don't really need to talk about that. It deals with termination of an agency, how you go about that, termination by action of the parties. It's called something different whether the agent is terminating it or whether the principal is terminating it. Can be, there's a couple of terms there, renunciation and revocation are the two terms that are, and then the possibility of wrongful termination of an agency or an employment contract. You can have termination by operation of law. There are even irrevocable agencies that cannot be terminated. So, sorry we didn't get to that, but we got through the main stuff that I wanted to go over with you. But I'm happy to have the questions. I'd rather have the questions and not get through all the material than to get through all the material and everybody be asleep. Farida?
Yes, I just wanted to make sure when you said for next week to read the chapter prior to the class, is that only for next week or is that for this class period?
It's for the class period, and I wouldn't say that's a hard rule, but it's helpful if you read the material before you get to class, and then you'll have questions about the material.
Oh, I see. Okay, thank you.
You know, if you're just listening to me talk about it, it's not going to mean as much to you as if you've already read it and been exposed to it once. And so we're going back over it and explaining it. That's the idea.
Yeah, it makes sense. Yes, thank you.
Okay, Gina?
Yeah, you had mentioned something about the assignment about agency that you were going to go over with us, I thought.
Well, I thought I did. The first one is first one has to do with a corporation who has a registered agent, and there's a form that you fill out in order to submit it to the state. It's the corporation authorizing the change of registered agent.
Okay.
So the corporation is advising the state that they want a different agent.
Okay.
That's the first assignment. The second one, so that's fairly straightforward. You can get forms for that from the Secretary of State. If you're doing it in Texas, Texas Secretary of State, I know has a form, and most Secretaries of State are going to have a form for that. I think they all will, which is the easiest way to do it. Just get the form from the Secretary of State and fill it out.
Okay.
The second one is actually a drafting assignment, where you're to draft a power of attorney for a specific situation. Somebody wants some additional office space, and they're retaining an agent to go out and sign, to locate office space according to the specifications that are going to be given to the agent, and then to sign a lease for a certain period of time, not to exceed so-and-so. Specifications to be provided by the principal. So it's a specific task, and you're not going to find a power of attorney for that specific task. You'll find powers of attorney that have to do with the purchase of real estate. That's not what this is.
Okay.
This is going out and looking for something and finding it and signing up a lease. You'll find general powers of attorney, just to do anything and everything, you know, like a general power of attorney. Legally cloning yourself. You don't want to do that. So what the task really is to tailor, to change, alter whatever form you find to fit the circumstance.
Okay.
So it's a little more than you've done before. Probably your first drafting task.
Okay. Okay, thank you.
You bet. Anybody else have a question about anything before we go? We won't generally run over like this. I just was not watching the time and I got wound up, and I apologize. We'll keep it in between the lines from here on out. All right. Well, I hope you got something out of it. If you get confused with me, let me say one other thing. We've had some problems with some of the questions that are on the test. Some of them are tricky, and some of them are difficult. So watch out. If they're under review, we're looking at them, we're going over them. If there are things that you think are not right, that it's a wrong answer, or it's misrepresentative, or it's just confusing, and you know, if you have any complaints, okay, come bring them my way, and I'll deal with it. Gina?
Sorry, I didn't take it off.
Oh, okay. I'm sorry. Antoinette?
Yeah, actually, that's what I was going to talk to you about, the self-test. I have found Because when I do the self-test, I take notes so that I just do it over and over until I get to a point where I feel super comfortable before I take the actual test.
Mm-hmm.
And I have found 2 answers that none of the answers are correct.
Okay.
So
if you find something like that,
I'll just email you. How about that?
Yeah, that's the way to do it. Send me as much of the question as you can. You know, if you can copy the whole thing and send it to me, that'd be great. But that's a simple typo. Whenever these questions are put in, like if it's a true-false question, you know, it has to be one or the other. But believe it or not, sometimes neither one of them gets checked, and then you've got a question where neither answer is correct. So it's a simple thing to fix. We just have to know about it to fix it. And there are a lot of questions. You know, there's maybe 80 questions for each chapter. Over 10 chapters, that's 800 questions. That's a lot for me to review. So the only way to do it effectively is just when you if you find something like that, let me know and I'll fix it.
Okay, I mean, yeah, off the top of my head right now, one of them is about the minor and entering into a contract, but I will go through my notes and I'll probably email you tomorrow and let you know.
Okay, great. That'd be great. Frida?
Yes, is this only for this test, for this first chapter, or again, is this for this class in general?
About the
that
questions?
there is some problems with tests?
Well, I'd like to say it's just this chapter. The first 2 chapters are kind of difficult material, and so I think there's been more problem in the first 2 chapters than there has been with the rest of it. But we found some errors in the database. So I just wanted to warn you of that. We're looking at it. We're aware of it. But it's, you know, we're doing the best we can.
Yeah, I appreciate you telling us. Thank you so much.
You bet. Virginia?
I just have the same question as Frida. I was wondering if it's going to be like that in every chapter.
Yeah, it's mostly just chapter 1 and chapter 2, but you know, a typo can occur anywhere.
Okay. Okay, thank you.
You bet. All righty. Well, good night. I'll see y'all next time. Well, no class next week. Remember, no class next week because it's Thanksgiving, but assignments are due Wednesday, and then you'll have a recording to watch, and you'll have assignments for the next week. So I'll see you in 2 weeks. Good night.
Good night.